microphone.
Weird.
There, right. Yeah, because otherwise it.
Okay.
Good evening.
Good evening.
You are live at Courtside with Lawman.
And Carmen B.
And we are here to talk about legal issues that affect the community and the public.
Absolutely. And we are merely an advice, or not an advice, but we merely are an educational program that tends to discuss issues in general. And we do not have an attorney-client relationship with you when we discuss these types of things, because we would like to keep things a lot general.
Yes. And we certainly welcome you to post questions into the chat, to call in if you have questions or comments that you want to make.
Absolutely.
You can call in at 916-443-5288. Again, 916-443-5288. And as Lawman said, we are an educational and an informational program for the public.
Yes. Let's see. It is Friday, the weekend before Christmas time comes. Recently, we had a big power outage downtown at the courthouse, and it happened to take up the 4 blocks or so, which hit both of our offices.
Yes.
So
actually, more than 4 blocks. It had to be, it had to be more than that because it went all the way to L Street.
Okay.
Yeah, there were lights that were out at L Street.
Okay. Yeah, huge grid and a huge fire. I mean, about 11:30 on Wednesday. I think 11:30 on Wednesday.
No, I think the fire was actually on Tuesday. I think it was
actually on Tuesday?
I believe it was on Tuesday.
Okay.
Yeah.
I know it. We were sitting talking jury instructions in my trial, and the lights went out, and then the generator kicked in a little bit, so we got to get down on the elevator. But there was a huge fire right a block or 2 away.
Yeah, there's a transponder station that is directly behind the
jail.
Sacramento County main jail.
Yeah.
I don't know how people in jail fared during that because, the electricity was out. I'm sure the jail probably has some sort of generator. System.
Right. Yes, I'm pretty sure they do. The court did. So.
Yeah, but both the jail and the court were then closed and then closed that next morning.
Right.
Until they were able
about
to
1:30 or so, they started calendars again. But they had moved things over to Friday and Monday of next week.
Yes, but that did probably create a huge problem for people who were trying to show up to court. I think a lot of times people assume that because we're such a technological society that everyone has immediate access to the internet. But there are probably people that do not. And so we're not aware of the dates that their court appearances were moved to.
Right.
The courts also indicated that they would mail out notices to people, but that doesn't help people.
Takes a few days. Yeah.
It does, but that doesn't help people who don't have addresses, who are unhoused.
Or their addresses are not updated in the system or something like that. So I think they'll be giving even more levity, though, to individuals who might be failing to appear or something in the next few days or something like that. So I know they put something that was set for Wednesday over to Monday, 3:00. So they've been trying to fill the calendars in as far in advance as possible. But I know they had over 200 cases on in a lot of jail courts this morning. It was wild.
Yeah.
I never seen 200 cases. So.
You have. You just don't remember.
What happened?
I don't.
All right.
Yes.
My internet's tripping. All right. Okay. So tonight, we were going to talk about trials, verdicts, and mistrials.
One thing I think that there are people in the public who don't realize what happens on a case if the jury is unable to reach a unanimous verdict.
Correct.
Unanimous meaning all 12 agree. All 12 agree that the person is either guilty or not guilty of the charged offenses.
And it's at that time that there's actually a true verdict and a, let's say, conclusion to the trial.
Yes.
Because we know if in fact we have what's called a hung jury, the jury does not agree, then there are some options that Carmen's going to talk about because she's experienced that this week with her trial, and I've experienced a couple of things too with trials.
So what the public needs to understand is, one, the jury is not required to reach a verdict. Each and every member of the jury is supposed to evaluate the evidence for themselves. Then they are supposed to discuss it with the other jurors, um, as to how they view the evidence. So, someone may have one view of the evidence that, after discussion and deliberation with other jurors, changes their view. And that is certainly fine to have that occur.
Right.
But what a person should not do is change their view of the evidence merely because they are being pressured by other jurors, or merely because the greater number of jurors are viewing the evidence that way. When there are multiple defendants, each defendant is entitled to an assessment of the evidence, um, as it relates specifically to him. I like to say there is no birds of a feather flock together when it comes to jury verdicts. So you can have two people charged in the same case where one person may be guilty and the other person may be not guilty. You don't have to vote the same way just because the two defendants are charged in the case together, because the evidence may be weaker against one and stronger against another, or it may actually be weak as to both of the defendants. And therefore, there should not be a guilty verdict to either of them. Um, when we talk about hung juries, we're talking about juries where there is a split. All 12 don't view the evidence the same way. So you might have 10 jurors who are voting not guilty and two who are voting guilty, or vice versa. You might have 10 jurors who are voting guilty and two who are voting not guilty. Neither of those should change their position merely to appease the greater number of jurors. It should be based on their analysis and their view of the evidence that came in during the course of this trial. It also should not be based on bias or sympathy, either for either side, not for the defense and certainly not for the victim. Sometimes in a case, you do have witnesses that testify who may be victims of something, but it is not a fair process to punish someone who did not. The evidence does not prove that that is the person who committed the crime. Punishing someone merely to help that victim to feel that justice was done is not actual justice.
True. Now, do you address that in your questioning of the jury, Carmen?
We certainly attempt to address that when we're doing voir dire, but as you know, there is no number of things. I mean, you can try and discuss all of that. Juries sometimes will still find things that we, as the attorneys, have not thought of in terms of how to view the evidence. So we try and cover that as much as possible, that each, if there's more than one defendant, is entitled to their assessment of the evidence as it pertains to that specific person. So you can never say, or should never say, a juror shouldn't, well, because this guy did it, then this guy must have done it. No, you have to apply that very high burden of beyond a reasonable doubt as to each and every single element of the crime that is charged.
Now, is there a jury instruction that orders the jury to do so?
There is.
Do you know which one it is?
The number?
Yes.
Well, off the top of my head, I can't, but I'm sure that you, being lawman,
yes, I do. It's actually in the very first instruction, they talk about how you have to judge each person independently. And in voir dire, one of the things that I use is I ask everyone about football teams, that we're not here to pick a football team. We're here to pick a jury, and not a football team in the respect of, if you were drafting players, what you would do is draft a quarterback, you draft a running back, right? You would draft wide receivers, you would draft defense players, things like that. Everybody has a different role that they would play. And as long as they play their role, then they will then be better as a team. Well, a jury is not a team. The only thing the jury should do is should be 12 independent individuals who review the facts and then make a decision on the facts. So I always ask them and tell them that we're not trying to pick a team here. And so what I want to always know is whether or not they can think independently. And if 11 people thought differently than them, will they be able to stand for their position if they were the one against 11? And I explain it so that I understand that they have personalities that don't speak up, and individuals don't want to say anything in front of people. They have fears about that. And so I ask them if that's what their personality is, to leave. I want them to say that that's their personality. They can't deliberate properly. And then we can get rid of them for reasons known as cause. So that's how I deal with it in the beginning, and try to explain to people that it's not a football team. You're not there so that everyone does one part of review of the evidence and then come together and talk about it. You independently have to decide what the facts are. And then I reiterate it in my closing argument. So, hung juries. Anything else on hung juries, Carm, they should know?
Well, just that the result of a hung jury is that then the district attorney can decide whether or not they are going to retry the case on the charges that the jury was hung on. And that's the other thing. You can have a jury that actually finds a verdict as to one or some of the counts,
Right.
and hangs on one or more of the other counts. But the counts on which they hang, meaning they're not all 12 deciding for guilt or all 12 deciding for innocence on those counts, whether it's 11-1, 6-6, 8-4, the end result is the court declares a mistrial, and then the district attorney will decide if they are going to retry those charges. Now, when the charges are retried, it is not before that same jury. The entire process happens all over again. A new trial date is set. A new jury selection begins from a panel of entirely new individuals, and a jury is selected, and that jury could view the evidence differently than the original jury had.
And that's happened many times in your career. It happens. I've even had to try cases 3 times when there's an 11-1 guilty and then 11-1 guilty. The prosecutor is trying to get that one juror that can flip and turn. So a hung jury doesn't mean everything's over with, but it's great to have the vote in your favor, because then the prosecutor has to realize that I may never get 12 people to agree
on this particular evidence,
right,
and that the case is not as strong as they believed it to have been.
Correct. Now, we said something about verdicts, so a jury comes out and they issue their verdict, and they are issuing a verdict on the charges that they're given. But sometimes you ask for lesser related offenses to certain charges. And if that occurs, then the jury can find a person not guilty of the charge, but yet find them guilty of the lesser related charge. For example, attempted murder. A lesser related offense might be assault with a deadly weapon if there's a shooting involved. And there will also be an allegation of discharge of a weapon that goes along with it. If they find you not guilty of the attempted murder, then they could find the person guilty of the assault charge, because the intent needed for attempted murder is completely different than the intent necessary for assault charges. The intent for assault is just doing the act itself. The intent for attempted murder is sometimes premeditation, deliberation, but definitely doing some conduct that involves malice, which means depraved heart, disregard for human life. those kind of acts. That's why a person who walks into a room or someplace and just starts firing could be attempted murder, because you knew by your actions that damage was going to happen. People would lose their life.
I would note we have a comment from Zenway Maba Safa Walker. I think this is in reference to the juries. Think independently instead of the mob herd-like mentality. And that is exactly correct. A juror should not just be going along to get along, as the saying goes. They should be analyzing that evidence as they saw it and as they heard it. Now, they are to discuss it with the other jurors. And if they are convinced to change their opinion based on the evidence, but not just based merely on more people believe it to be true than not.
Right. And that it's a danger that can happen in any jury room, that people just tend to flock together and want to appease others. A lot of times what happens is when a jury is hanging, when they cannot decide, a judge will bring them back into the courtroom and give them what's called a firecracker instruction.
Yes.
Which is actually meant to pop a whip, so to speak, and make them do things that are different in order to come to a verdict, like switching sides and making different arguments and stuff. Now, and doing all kinds of things. I always look at the firecracker as an illegal instruction, and I would object to it because it is now just ordering the jury to do something that is not normal in deliberations. It's actually the judge saying, go back, just, start again, play different roles, do all kinds of things.
Basically play devil's advocate. If you are one of the people who is voting for guilt, argue for innocence.
Yeah.
Now, I will say this, the law does allow that instruction to be given. We certainly object to it, but usually it is given over our objection. I view it as an instruction that is telling the jury that they need to reach a verdict. And since we know that the majority of verdicts in that are given tend to be guilty verdicts, and that's just facts, that it's kind of swaying them and saying, you can find guilty on this case.
Sure.
And so for that reason, I dislike it. Now, the judge does not direct them to do the things that the court is suggesting in terms of playing devil's advocate and arguing the other side, other than the side that they are currently aligning with.
They suggest,
but they suggest.
Yes.
Suggest that they do that. They're not required to do it. They could go back and choose to deliberate in some other fashion. Right. But sometimes if you have someone whose personality is not strong and now they are being, or more than one person, and they are being pressured by the others, that can result, I think, in a verdict that should not be.
And you see that sometimes when a jury is out 2 days, and here we are on Friday. Yes, and it's 4 o'clock on Friday after being out for a couple of days, and all of a sudden they have a verdict.
Or just it could be there that entire week.
Day,
but that Friday comes, and jurors are thinking, hey, I've been here long enough on this case. I want to get back to my family. I want to get back to my job and my normal life and not have to deal with and think about this anymore. So we have to also try and build that in when we are doing voir dire, which is the questioning process that occurs when you are selecting a jury, that people realize the seriousness of the task that they are undertaking, and that they can't rush it just because it's Friday and they would like to get back to their normal lives.
Right. And one of the things that you can do, and what happens is, if a person feels bullied, that jury, that one person who's the standout, who may feel bullied by others because they, somebody's walking around, come to your senses. Why can't you see things this way?
And sometimes it's not just one person. It could be 4 people, but if they're being pressured by 8, and if they aren't if they don't have the personality where they
cordial,
can stand,
yes.
yeah, you want to. The process requires that they be cordial. Jurors shouldn't be arguing and fighting with each other.
Right.
They're viewing the evidence and the
differences of opinion.
Yes, and
That's
those
all.
can occur, and those are supposed to occur in a cordial atmosphere.
And really, that's what this is built for. I mean, that's what the jury system is built for. That's why they say jury of your peers, because it's supposed to be individuals who would be like you, who would come in.
Now, we've talked about that before. It's not jury of your peers really means people from your community. So it's not going to be people who necessarily look like you or in your age group or in your social economic group.
Oh, it may not be, but that is why all Black people need to register to vote, need to register their vehicles, because right now it's important, because if you have a felony, you still can serve on the jury. You need that one person there for perspective to say, no, that's not the way something is done. And it might be an ethnic thing, you see. I mean, I've had it over braids versus dreads. I've had it over the fish man, the guy who drives in the neighborhood and sells stuff.
It is good to have a diverse jury because you get different perspectives
Cultures,
yes, and just of daily life,
right. Poor versus rich life, I mean, people who have not,
or greens versus greens.
Yeah.
And by that, some people refer to greens, the southern meal that is boiled, versus greens as in a cold salad. So
Kale.
Both of those are the same word, right? But it means one thing to one person, and it means something else to a different person. Exactly. So that diversity is
necessary
good for that.
Yes,
good and necessary to bring those other perspectives into that jury room.
Now, I want to drop something. Next year, there is a law that tends to give peremptory challenges a challenge, meaning this, and I hear this is going to happen. It is basically a peremptory challenge is a challenge that you can make against a juror for no reason. You don't have to usually explain, but you're not to use gender, race, ethnicity, or what's the last one? Religion. You're not supposed to use those as a basis for getting rid of a juror. You have to have some other cause, reason, like why the person would not be fair, impartial, and unbiased. The new law puts a hamper on district attorneys who want to kick off Hispanics only, Asians only, and especially Blacks only, or women only, or Middle East only. You see? And the new law has far more stringent requirements for kicking somebody off, to where I understand that what is going to happen is that if you're a district attorney and you don't have more than 40 trials under your belt, you will not use a peremptory challenge. Meaning you're not going to kick anybody off for that reason. Now, that you know what that signals to me? We, as Black people, need to get on these juries now. We have to get on these juries now, because they're just not going to boot you off because you have issues with law enforcement. You've had issues with your family and law enforcement, and use that as an excuse. If they don't kick you off, you're on the jury. And now that perspective, that cultural perspective, the racial perspective, the diversity necessary is on the jury. So I'm stressing every time we talk, I keep saying, register your vehicles, register to vote, because we need people on the jury. If we don't climb up and get in the jury, then the windows close.
And we can't complain about what the jury is doing if we're not willing to do our civic duty and sit on the jury. Now, I realize, of course, it's easier for someone who is a person of means to take that time off from work. But some employers, and you never know unless you inquire, do pay for the time that you are on jury service.
State service, they're going to pay. Counties, they're going to pay. Any government operation, they're going to pay.
Yes.
And a
Yes,
lot
and
of
then private
corporations will.
employers,
Yes,
you need to check with your employer and
exactly.
see whether or not they pay your wages while you are on jury duty.
Correct. And some trials are 2 days, 3 days, so they're not that long anyway. And you, if you're removed from one, you could ask to be on a shorter trial and then actually sit on another panel. So we talked a lot about
I just was going to say, I think the bill that you were talking about in regards to the peremptory challenges is AB 3070 for anyone who wants to
look it up.
Look it up.
Yes.
Which kind of already existed with the Wheeler motion, but it's
it changes Batts and Wheeler around to where here's what the real insider scoop is probably what's going to happen if prosecutors don't use peremptory challenges. And let's say I did, and I kicked out all the Asians, I kicked out even 5 white people. It may be then I have to explain why I kicked those people out and justify that.
Oh, that applied with Wheeler as well.
Oh, sure.
I once got Wheeler where I was the I was the defense, and
you kicked off too many black people, Carm?
I got Wheeler. No, that's not why I got Wheeler. I got Wheeler because they said that I was kicking off white males.
Yeah. Now, see, and if the DAs are not using the challenge and we start kicking off white males, we're going to be challenged.
I don't foresee them not using the peremptory challenges.
I hear. If you don't have 40 trials, you have to get permission from a bureau chief to use a peremptory challenge.
Well, we shall see.
Oh, we are going to see because the new year shall be here in about 13 days. So we're going to see.
No, not that soon. No.
Okay, it's the 7th. What day is it?
Today's the 17th.
13 days. New Year's will be here. December 30th?
14th.
All right, 14. Fine. I was skipping Christmas.
You're not allowed to do that.
It's a holiday. It falls on a Saturday now. Oh. All right. So anyway, we're talking a lot about trials, verdicts, mistrials, because a lot of people hope, God forbid, that you have to find yourself in a trial. But know that how your lawyer handles that jury up front and lets them know what they're looking for later or what to look for later is kind of important. And if you find yourself in that and you're going to trial with your lawyer, ask them, what's their plan for voir dire? Who are we looking for? What kind of juror do we want?
Well, the other thing that I do is this, and I'm sure that you may as well. My client participates in the jury selection.
Absolutely.
Because they may see something that I did not see.
Right.
Because it's not just based on how a person answers the question, but it's also based on their body language.
Yes.
Are they staring at my client angrily? Mm-hmm. Are their arms crossed? Does it appear that they're not open to the process?
Right. Like they keep on trying to get off the jury, and say.
Or is there someone that is too eager to be on the jury?
Right. They've been on several juries before, so they're a jury candidate.
So there are a number of factors that can play into jury selection.
And I want you to know, look, this isn't about trying to trick anybody or anything in order to get a not guilty verdict. Yeah. It is all about trying to get a fair trial, which is guaranteed to us under the 6th Amendment and definitely 14th Amendment, equal protection and things like that.
Well, there are things that are guaranteed, and we try to make the system live up to what
the notion
promises,
of it, right?
The theory of what it should be,
right?
Because we do know that there are trials that are not fair, and where justice is not served,
right? And so that's why, in a way, that's why I do what I do. And I do it so feverishly,
Yes.
It doesn't matter to me, guilt or innocence. I don't walk into a case saying, oh, well, you're guilty? Well, easy job for me. I don't even want to know. And I don't need to know, to tell you the truth. Because as a good lawyer, you can see things. And you got to prepare your client for whatever outcome, that there may be. At least before you walk into trial, they must know all risk that can happen.
I want to say hello to Zimbabwe Asafo, CC Badger. We see you.
Yes.
And Marianne, we appreciate you guys being here.
Yes.
Spending your Friday.
Right.
We do encourage you to
give us subject matters.
Yes,
to
give
talk
us subject
about,
matters,
sure.
but also tell your friends and family and anyone that you know that may have questions. I think we're having a little bit of technical difficulties with our camera. We keep seeing it.
It speeds up and stuff,
yes.
So the internet's still tripping down here.
Yes.
Yeah.
So we apologize for that if it's causing any problems.
Yeah.
We again appreciate you. We appreciate your viewership.
What are we doing tomorrow, Carm? Are we going to talk to some?
Yes, that is right. We there is an organization, Our Daughter's Destiny, that is having a mixer tomorrow from 6 to 9.
Yes.
You can,
and I think look them up.
Yes, Our Daughter's Destiny.
The Old Dante Club tomorrow. Yes. But what they do is they're doing a lot of work and people coming who are transitioning from prison
or jail
back into the community. That's what they're doing. There are groups like All of Us or None, Justice to Jobs, and here's another one that's trying to help people transition. So I think we've been invited to come by, talk a little bit about knowing your rights and things like that, and the criminal justice system in general, and how to stay away from it.
So it is tomorrow, December 18th from 6 to 9 p.m. at 2326 Fair Oaks Boulevard.
The Old Dante Club.
Suite J. And it's their first annual community mixer.
Right. So what they're trying to do is connect people in the community to try to have many hands do better work than just one group's out there solo flying alone.
So that there are multiple resources coming together. So if someone needs help in the educational field, we can direct them this way. If someone has criminal law issues, they can send them our way. If someone has a housing issue, they can help them that way. So it's a number of organizations coming together to figure out a way to help people basically matriculate back into society so that we don't get recidivism.
Exactly. And recidivism works for everybody. I mean, lack of recidivism works for everybody.
Yes, not having a recidivism. And when we know this, when people don't have the support that they need, and they may have to return to doing criminal activity in order to survive, because it is human nature to want to survive. But if they have support systems in place, they won't have to resort to that kind of activity.
Right. And we reach a goal of reducing at least so many people running through the criminal justice system.
Yes.
All right. I think it's time, Carm.
All right. Again, thank you for spending this time here at Courtside with Lawman
and Carmen B.
All right. Have a good evening.
Take care, everyone. Please stay safe.